Welcome back, everybody, to the Aaron's High Cap Adventure Radio program. Again, it's August 26, 2017, and we are now in our License to Carry Attorney segment. And to my left here, I have Super Attorney Rick Dodd. Rick, as always, welcome to the show.
It's great to be here. I went out last night, and it was windy. It was windy as my ex-mother-in-law. But today, it's a lot better, so I'm looking for a great turnout for our Steelworkers Picnic over in Rockdale at 11:30, about an hour from now. I know Boyd Taylor's over there based in the barbecue right now, so don't
I'm
miss out.
assuming it's under shelter.
Well, you would hope so. But
Okay.
You know Boyd.
Okay. Well, Rick, we got a few things we're going to be discussing this segment. And basically, legal liabilities of signing affidavits I wanted to go over, disabled persons defending themselves and how the law looks upon it. And once again, possession of a firearm by a child 17 or younger in a self-defense mode. We've gone over that one quite a bit. However, I've had a lot of people come up to me with confusion about how is it legal if it's contradictory if the child got access to it. So any one of those three, however you want to start, let's do it. I see all your notes here, and I'm sure you're totally prepared. So ladies and gentlemen, if you got any questions on this, give us a call here at 254-697-6633. And for all of you on the West Coast who are listening, toll free at 866-504-1051. That's 866-504-1051. Go ahead, Rick.
Well, there's nothing magical about making a firearm accessible to a child. It's illegal. It's illegal to have a readily dischargeable firearm that a child can get to that is unsecured. And secured means, excuse me, that which a reasonable person, the great reasonable person would figure is secure.
I haven't found that person yet, but go ahead.
But anyway, if they've said if it's in a locked container or temporarily rendered useless by having a trigger guard on it, that would be good enough. But of course, secure may also mean way up high for someone who's way down low and doesn't have access or ability to climb a ladder. Secure against those kinds of things. But there's what we call an affirmative defense. Means that we, or the person who's being charged with the crime of making this firearm available to a child, has the burden of proof. Now, you've heard 1,000 times that the state always has the burden to prove that you're guilty beyond a reasonable doubt.
Yes, we've heard that.
But in affirmative defense, the burden shifts to you to prove certain things, and it is an affirmative defense to this crime if the child is supervised by an older person. A person older than 18 is in hunting, sporting, or other lawful purposes. So that doesn't mean that someone who is a child, and a child in this section is 17 years or younger, can't have a gun. I mean, yeah, you can have a gun as long as you're supervised in the process of sporting. That makes sense. Now, this defense of other people or other property is also affirmative defense. In other words, if your child is at home and your castle is being broken into, or, we've talked several times in the last few weeks about what it means for self-defense. And it's got to be a lawful defense of people or property for that child to have that gun. And if you can prove that lawful defense, then you're off the hook.
I want to add some stuff in here in case you can utilize it for explaining. Not only have I had tons of questions from people local, but down in my instructor training class, this came up, and instructors were debating back and forth on this particular one about how using the gun for self-defense or protection of property from somebody 17 or younger and having access to the firearm is contradictory. How does that work? Because the gun obviously was left in the open for the child to get it, or was given access somehow without supervision by a parent, adult, or guardian.
Well, I agree. It's contradictory, but it is an affirmative defense if you have one of those things. So I mean, it has the stuff about the sporting or other lawful use. It has the stuff about the child protecting people or property. It also has to do with if a child were to break into your property in violation of the laws and get the gun. That's not your problem. That's not your fault.
Okay, let me give a scenario, because I know there's tons of people out there listening. They're going to ask me more questions. So I'm going to lay out the most basic scenario, and then I think I know what the answer is, but I want you to say what you're going to say. Here it is. It's 9 o'clock at night for some reason. Parents are coming home late. They should have been home an hour ago, but Harvey hit with the rain, okay, and they're stuck. And there happens to be the Glock pistol on the coffee table, and somebody's breaking in. The child, 17 or younger, in fear for his life and the property, picks up that Glock, defends the home, saves the day. Everybody's screaming, well, he may not be charged as a defense because it says it in the law book, but the gun was there all the while unsecured and the child had access to it. So the law is just saying we're turning our heads on that one?
Basically, that's right. Again, it's an affirmative defense. In other words, the prosecutor can go ahead and prosecute you. You have the opportunity then to prove that this exception fit into the mold, and the jury then would have the opportunity to let you off or not.
And it's like you said last week, I believe, they're not going to prosecute you unless they've got reason to prosecute you. If they see that the child defended themselves with the handgun, that yes, it was out in the open, but because it says it here in Penal Code 4613, they're not going to prosecute you because there's nothing to prosecute because the law specifically says it's not a defense because it's written in the law, right? I just repeated myself like 3 times there.
I think you're right.
Okay. Well, if you think I'm right, my gosh, mark that down in your calendars.
Well, one other thing that I missed a minute ago, that it's also an affirmative defense if this offense occurred during a time when the actor, and the actor's the parent, if you may, was engaged in an agricultural enterprise. Now that's wide open, isn't it? So I think that was particularly for the hog hunters.
Okay. So do we have any questions? If you got any questions, give us a call, 254-697-6633. For all of you on the East Coast, it's 866-50, anywhere. Give me a call from, I know you're all listening on West Coast and East Coast and everywhere in between. It's 866-504-1051.
What's also interesting about that, Matt, is the U.S. Code has a particular Youth Handgun Safety Act. And the U.S. Code, which covers all the land, it talks about how the possession of a handgun or ammunition by a juvenile taken in defense of the juvenile or other persons against an intruder into the residence of the juvenile or residence in which the juvenile is an invited guest is an affirmative defense. So it's not as wide open as our Texas law is, but they both apply, so either way.
Okay. Hopefully that answers everything.
Yeah,
Basically,
I mean, if
the
you travel
laws,
into another state, you're at least covered by the U.S. Code.
basically, bottom line, and I'm not going to hold you to this, basically they're turning their heads the other way in that particular scenario. Otherwise, if the child gained access to it and somehow they were to prove in a court of law that he had access without supervision, the owner of the firearm would get at least a Class C misdemeanor.
At least. Typically, nobody prosecutes this case unless there's a shooting. And either the child shoots himself or another child. I've had cases like that in my career where that's just happened. And of course, everybody's real sorry about that. But the prosecutor can prosecute whoever owned the home or had the child there at the home, if you may.
Gotcha. Okay. Let's move on to one of our other topics here. And I think let's talk about affidavits, because in my license to carry class, let's just face the facts, ladies and gentlemen. A lot of people who take the license to carry class do it because they have to, and they want to get in and out as fast as they can. Others are truly interested in knowing the laws and learning any little tricks they can in that short class that we provide, that the state mandates certain time frames and all that. And I warn my students, you better know your stuff, because when you go to apply on the state website to get your license, you're going to have to electronically sign, I believe it's 3 affidavits. And so don't take that lightly. So with that intro, Rick, why don't you explain to us what an affidavit is, penalties, how important it is, so on and so forth.
Well, I mean, that's real simple. That's perjury. And we all know perjury is illegal. So, the affidavit, of course, is something where you swear to. I swear, you hold up your right hand if you may. You don't have to hold up your right hand. But whenever you sign it or you click the button saying I accept, you are swearing that the stuff that's in that affidavit is true and correct. And that affidavit is being used as a governmental document. And governmental documents are governmental records or court records. If you lie, fail to tell the truth, if you may, because you're supposed to tell the truth, the whole truth, nothing but the truth. Remember that.
So help you God.
That's right.
Okay.
If you don't do those things, you are committing perjury. And of course, the amount of perjury, if you may, or the penalties for that perjury depends on several factors. There is perjury and there's aggravated perjury. And of course, I would think that the license to carry affidavits would be simple perjury, if you may, which would be a Class A misdemeanor, which, you know, is Class A misdemeanor, put you in jail for a couple of years. So
you don't want that. You won't be able to carry a gun either. So
that's right.
Think of it that way.
Any kind of a crime against moral turpitude, and perjury would be one of them, would limit you in a lot of situations.
I failed to pull up the affidavit that actually licensed to carry. I don't suppose you have an example of that. My failure on that part.
I do not.
Okay.
But you know a lot about it. What sort of stuff is it that you are?
Well, they're basically saying that you have read the laws, you understand the laws, you have done due diligence to take the course and read the penal code. You basically know what you're doing, and we're trusting that you listened, studied, took notes, practiced, and put to practice what you've learned, basically.
Yeah, and of course, you know, the big deal on license to carry is being proficient. And if you swear that you are proficient, and proficiency has to do with knowing the rules. If you swear that you are proficient and know the rules, and then turn around and cause harm and say, oh, gosh, I should have read that, then, you know, not only are you liable criminally for the harm you've caused, but you've also committed perjury.
And Rick, you know, this goes back to last week. I don't want to keep it real short. That's why I'm so adamant on verbiage and punctuation and all that, especially on the penal code signs, 30.6 and 30.7, because it's in there for a reason. It means something, and you have to be proficient in the understanding of that so you do not do something wrong, and to take out the guesswork. And if we have these things that are solid, something I can go to as solid as a rock, there's no debating it. That's the way it works. It helps to minimize any potential problems. That's why I'm so opposed to speculation or guesswork or opinion when it comes to the law.
Yeah, and of course, that's difficult sometimes because of all the nuances. But once you read the section, and then you read the exceptions to the section, and then the exceptions to the exceptions, you're going to get it.
It's crazy. Okay, what else you got on that?
Well, that's really about it. I mean, nobody really wants to be a liar or a perjurer. You know, and basically I said something about court records or governmental records, but that would also include things like if you were to lie to a police officer who was doing an investigation, or a federal special investigator, that would be perjury. Or if you tamper with any kind of physical evidence, you know, you hear on the news sometimes where a policeman spots some drugs in the car and the person tries to swallow them or throw them out the window. That would be tampering with physical evidence. Or if you tamper with a governmental document, say you go in and put a little whiteout on something in the court records that you don't like and change it, you know, and that's happened many times. That is a form of perjury. So, you know, we like to be able to depend on things, and one of the things we like to depend on is a court record, because if you don't tell the truth, bad things can happen to innocent people, or good things can happen to bad people.
That's right.
And also, you want to be able to go back in history and look at what happened, so we learn from that, of course. Also, it's illegal to file a financial statement that you know is fraudulent, because again, what you're doing is basically lying, cheating, and stealing.
What is, I think you said it for the child getting access as to what kind of charge it would be, like Class C, B, or A misdemeanors. On something like this, if somebody fraudulently does an affidavit, where do we start there when it comes to the law?
Generally speaking, we're looking at a Class A misdemeanor, which, you know, could put you in jail for a couple of years. Also, there's some financial penalties. Some of them are a little less stringent, Class B misdemeanors, which I think up to a year. If Ross Watson was here, he could probably tell you exactly what the penalties are, but I don't practice much criminal law. But some of them, if it's aggravated perjury, that puts you in federal, in jail, I mean, in the big house, so to speak. It's a felony.
What about the concept of, I don't remember? Yeah, I signed it. I knew it then, but at the moment I forgot about it. How does that come to apply? Because I remember back in court cases, the attorney would ask a question and the witness up there would just say, frankly, I just don't remember. And how do you argue somebody who doesn't remember? How does that work?
Well, you got to remember,
Maybe.
in this case, if you can, that the jury of 12 people are going to be judging this. And if you signed the document, the affidavit, at the time you knew what you were signing, but then you forgot it later, I think that would be a reasonable defense. It would certainly make more sense than saying, oh, I didn't read it.
And that's why I offer my license to carry class, obviously to new personnel, but people who have already got the license, I know you can get rusty. It's a perishable skill to remember all these penal codes. So whenever I do a license to carry class, everybody, I also offer at the same time a refresher course. The newbie is $60 for the class, and the refresher is $40 because I don't have to file all the paperwork for you. So we've got a class September 9th, Saturday at 2 o'clock. If you want to sign up for that class, anybody who wants to get a license the first time or anybody who wants to refresh, you can go to September 9th, go to aaronsgunshop.com and go to the license to carry page and sign up there, or just give us a call or give me an email at aaronsgunshop@gmail.com.
And of course, we talk about these penalties, these criminal penalties, Matt, and they're important, but you don't want to see your brother-in-law laying on the ground dead because you screwed up. I mean, you don't want to see something like that because you forgot or didn't think it meant such and such. I mean, these things can be some terrible consequences if you don't know what you're doing and you're not proficient.
And I always give these analogies like if you're baking a cake. Well, you're baking a cake and you forgot that you have it in the oven and it burns, right? What do? You get the fire extinguisher out, put it out, no big deal. But on one of these issues, if you forget, we're talking serious ramifications. So baking a cake, polishing your car, waxing your car, painting a house, yeah, you got to have skill in doing it, but it's not really a life-threatening situation. When it comes to penal code and license to carry, you must, I repeat, you must be proficient, understand it, or you're just being a wannabe, and you're going to cause trouble for yourself and a lot of people around you.
That's right. Anytime you handle a firearm, you have to be careful.
Okay, now Rick, I want to get into disabled persons. And my thoughts on this is this. Guns becoming an equalizer. If you've got a disabled person, let's say they're in good shape one day, but then because of whatever, accident or something, they're not able to do what they used to do. And let's say they look fine, but in reality they know they can't do what they used to in defending themselves, and they have to rely upon some type of weapon to defend themselves. And my thought is this, here you have a person that looks fine, but they know they can't do it, and they're using a weapon as defense. How does the law look at that for disabled persons, disabled vets, disabled individuals, people in wheelchairs, whatever it is?
Well, I mean, the law itself looks at the person who is actually holding the weapon. In other words, what is going through their mind? Do they feel threatened? Do they feel like they can retreat? Now, of course, someone in a wheelchair is going to have much more difficulty retreating than someone who can run the 100-yard dash in 10 seconds. So that person in the wheelchair has more protection under our laws, if you may, when he uses a firearm. He or she, in their mind, can be threatened. I mean, there are opportunistic criminals out there, and we know that they do take advantage of people who have certain disabilities. We have laws that protect older people, we have laws that protect children, and we have laws that protect disabled people by upping the penalties for someone who may hurt them.
But that I don't mean to break in here. That
Go
doesn't
ahead.
really seem very appealing to me. Yeah, that's great. I'm busted up and broken, and I'm going to feel better knowing they're just going to get a higher sentencing. That doesn't do me any good at the moment that I'm getting beat up, though, to comfort me.
Well, the thing about being disabled is, and firearms, is that you have to still be proficient with your firearm if you're going to use it to protect yourself. Otherwise, it's just a piece of plastic or a piece of metal that might actually get turned and used on you. So when you're talking about the abilities and the disabilities, the person has a right under our Second Amendment to have a firearm, and they should have that right. There's been quite a bit of debate lately about what it means to be disabled mentally, and there's been some laws like in California in particular, they have made laws that have made it illegal for certain people with mental disabilities to have guns, and that really is a violation of our Second Amendment. And you got to remember that us, as moral majority people, we don't get to make all the laws. That Constitution is there to protect the people who don't always agree with us. I mean, it's easy to say, this mass shooting would never have happened if this person had not been mentally unstable. It's easy for us all to say, gosh, anybody who does this sort of thing has got to be mentally unstable. So then we start making these laws about, well, if you have been adjudicated mentally unstable, or if you have talked to a psychiatrist about hurting yourself or somebody else, or if you have signed for Social Security under some sort of situation where you're saying I have a mental disability, then you cannot have a gun. It's easy for us to say that, us who don't have those problems. But the reality is the mental disability could be something as simple as falling asleep at the wheel, which wouldn't have anything to do with your ability to protect yourself while you're awake. It might have something to do with, I have a phobia against snipers up in high places. It could be simple stuff like that, that these laws are too overbroad, and it denies the person who has a disability or who claims a disability or might have a disability that doesn't have anything to do with them being able to use a weapon proficiently. It denies them their Second Amendment rights. And I'm all about the Constitution.
Yes, you are. I know that.
There are more to it than the Second Amendment, of course, which does allow other people to talk about it and discuss their feelings, but it should limit the ability to make laws against people who shouldn't have those laws made against them.
Rick, I got a scenario here, and this is not an open ticket for somebody to just go ahead and do this, but it is common, I think. You can't use deadly force based on verbal provocation alone. But what if you're disabled and you cannot respond quick enough? You think you're getting into that point, the threat is about to happen. And maybe if you were able enough, you could do step 1, 2, and 3 before you had to use deadly force, but steps 1, 2, and 3 are out of the question because of the disability. And you feel, man, it's at that point, but he's just talking up this game, but I'm getting scared. Can an individual at that point, do you think, say, I don't have the speed, I don't have the ability, I don't have any other considerations to use other than this one thing to stop the threat? In your expert opinion, how do you think that would go?
Well, again, it has to do with the concepts, the thoughts, the state of mind of the person who's being threatened. In other words, all these laws that we've been talking about over the weeks, they all stem from the person who is the shooter, what they thought, what they perceived, and how they perceived it. But, again, like I said, this is no magic talisman. This is no opportunity to have something sitting there that's going to always protect you. You have to use your best thought on what to do next, and be careful if you're unable to proficiently use that weapon. Be careful to pull it out.
It's almost impossible. It probably is impossible just to come up with an answer for every situation. Obviously, it's impossible. You just have to do it. That's why, like Rick always says, you got to look at all the facts and the figures. The devil's in the details, I guess. You look at all the things that are happening, and based on the jury of 12 and their opinion and emotions at that time, will determine what it's going to do. So the best thing to do is know it the best of your ability, understand the laws, understand yourself, understand your weapon, and apply it in the most diligent manner that works for that situation.
Well, I love statistics, and studies have clearly revealed that people with mental illness in and of itself are not statistically more likely to be related in violence, and that people with serious mental illness are much more likely to be victims of crimes than they are to be perpetrators of crimes.
All right, Rick, with that, we're out of time. I'll tell you what, tell everybody how they can get a hold of you. Ladies and gentlemen, he's awesome. If you need help, this is the man to go to. Rick, tell us how you get a hold of him.
Well, we do asbestos work, and when I'm going to go to the Steelworkers Picnic here in a little while and meet some of those poor folks who were affected by that. So you can get a hold of us by looking at asbestos law, respectforyou.com. You can give us a call at 697-4965, or you just come by the office on 312 South Houston. It's been there for 35 years. Same street that all the banks are on.
Fantastic. All right, ladies and gentlemen, I believe, Joel, we're taking a break now. We've got our bumper music coming in. And we're going to take a long break. And when we come back, we're going to go over topics of interest, things that are happening. And we've got our special guest, Paul Harvey, coming on towards the top of the hour. So we'll see you on the other side. Excellent. Thank you, sir. It's always a pleasure.
Mm-hmm.